Hello everyone. So I have decided that today is the day that I'm going to hop on board with this new video blogging. Well, I guess it's really not that new, but it's new for me because I have never done it before. Not necessarily comfortable talking to a camera, but I know that a lot of folks these days really like to receive information by clicking play on their phones or their computers. So I'm hoping that this first video and the ones that follow will help you guys get some answers to some questions that you may have about probate and guardianship. So today's question is, does a will avoid probate? And the short answer is no, not always. So the best way to think about a will is just simply a written roadmap to the judge of how a person wants their assets distributed. So the will itself is not self-implementing. The assets that someone has when they die do not usually transfer automatically simply because there is a will. So whether someone's estate can avoid probate is going to depend on what kind of assets they had when they died. So if the person passed away and they only had non-probate assets, their estate would not need a probate estate to distribute those assets. On the other hand, if the person passed away with a will, but they also died with probate assets, then chances are you do need to consult with an attorney, and there is a possibility that a probate estate is going to have to be opened so that the judge can read those instructions in the will and distribute the assets accordingly. So a few examples of non-probate assets would be life insurance policies that have designated beneficiaries, bank accounts that have listed payable on death beneficiaries, annuities, certificates of deposit that have designated beneficiaries. These types of assets that they will distribute to the beneficiary by operation of law upon the decedent's passing. So you'll have to, of course, notify the life insurance company or the bank, usually provide copies of the death certificates, fill out any death claim forms that the institution may require, and then those assets, because they are non-probate assets, can pass outside of a probate estate, and you would not have to open a probate with the court. Examples of probate assets that would require a probate, regardless of whether there is a will or not, would be bank accounts that do not have payable on death beneficiaries listed, life insurance policies that either do not list a beneficiary, or maybe they do list a beneficiary, but that beneficiary that's listed is no longer living. In that case, the life insurance company is going to make the life insurance proceeds payable to the deceased person's estate. So in cases like that, you would need to likely open a probate with the court so the court can then determine who is entitled to receive those probate assets. So hopefully that has answered a few questions. If you have any more questions, feel free to give our office a call. Our phone number is 850-741-2999. And I look forward to hopefully answering some more questions for you guys in the future. Hope everyone has a great day.